Welcome, everyone. I'm Annie Cartwright, one of the partners in Husch Blackwell's Higher Education Group. I'm joined today by two colleagues, formerly both with the Department of Education, Julie Maselli, Managing Partner of Husch's Chicago office, and Elizabeth Samples, who's another partner here in the Kansas City office with me. Thank you for joining today's webinar, providing an update on issues in some key areas around student funding. Before we begin, a few housekeeping items. You'll see application icons on your screen at the bottom of your audience console. Please submit any questions you may have during the webcast via the question box. We'll try to answer your questions during the program, but if a fuller answer is needed or if we run out of time, we'll try to answer later by email. A PDF of the presentation is available in the Program Materials folder. This program has been approved for continuing legal education credit. Live attendees can report their hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance will be emailed to you along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our brief survey. We use your responses to plan future programs that are relevant to your needs and your interests. A little more about our speakers. Joining me today again are Julie Maselli and Elizabeth Samples. Julie is a former Deputy General Counsel to the U.S. Department of Education's Office of Federal Student Aid. She has concentrated experience advising colleges, universities, and academic medical centers on, among many other matters, legal issues related to financial aid, including Title IV compliance, loan servicing, and collections. Elizabeth is a former attorney with the U.S. Department of Education's Office for Civil Rights and provides guidance on administration of Title IV federal student aid programs, which we all know is the hook for a number of other compliance requirements like non-discrimination, disclosures, and accreditation requirements for colleges and universities that participate in Title IV. She applies her understanding of these Title IV regulations when she's advising on internal operations, and her practice includes auditing institutional compliance and non-discrimination in Title IV federal student aid systems and making recommendations for risk mitigation in those areas. Again, I'm Annie Cartwright, and I also focus my practice around Title IV. I swear we're interesting people in real life. We don't only talk about Title IV. And I also focus on student funding issues and all the compliance spokes that go along with taking so much government funding and having responsibility for delivering quality education to our students. Speaking of student funding programs, we've seen some developments in key areas in the last several months. And today we are going to talk about issues related to income share agreements, sex-restricted scholarships, new locations where we've seen some challenges for institutions recently, as well as cybersecurity and other open and developing policy issues, including borrower defense to repayment. First up, we're going to talk about income share agreements. What is an income share agreement? Typically, it's where an institution or an outside private entity will extend credit or just dollars to students to fund their education. And in exchange, the student promises to repay funds at a rate that varies depending on the student's income after they leave the institution. Sometimes this means the students end up paying back nothing or very little if it's a limited time frame income share agreement. But at other times, it means that students can pay back considerably more than they initially received because they're fortunate enough to have high incomes. And there have been a lot of questions around income share agreements in recent years. In part, we didn't know what they were. We didn't know how regulators would treat them. Are they grants? Are they loans? Were they securities? What sort of disclosures need to be made? Were there caps on things like the amount of income that could be repaid, such as under state consumer interest laws and consumer lending laws? And in an interesting and somewhat rare turn of events, we have seen regulators actually answer some of those questions before they started pouncing on institutions of higher education for alleged noncompliance. The answers aren't exactly necessarily what we would have designed as advocates for institutions of higher education, but we did get some answers. And they are that in September, we saw the CFPB, the Consumer Financial Protection Bureau, issue a consent order against a student loan originator, and it found that in offering this income share agreement, the originator misled borrowers about the nature of the agreement, that it didn't provide required disclosures, and it violated the prohibition against prepayment penalties for private education loans. So that was our first clue. The CFPB is treating these income share agreements as private education loans for its regulating purposes. In its order, the CFPB concluded that the student loan originators' income share agreements are actually private loans, and they qualified for coverage under the Truth in Lending Act and its implementing regulation, which is sometimes called regulation or Reg Z. That means that certain disclosures have to be issued and certain rights have to be provided to the borrowers. Then in January, the CFPB updated its examination procedures for private student loans to specifically reference ISAs. So we saw a little more movement from the CFPB. And then just a few weeks ago, the U.S. Department of Education clarified that it's going to treat income share agreements as private education loans because it sees them as regulated under its private education loan regulation. The key impact on schools from these CFPB and Department of Education findings that they're private education loans is that schools should be approaching ISAs as they do other private education loans. The department has a bunch of rules around what you have to do when you are offering a private education loan or promoting a private education loan offered by another funding entity. And perhaps because of those rules, a lot of institutions in recent years have backed off of offering or promoting private education loans. So we haven't seen a whole lot of regulation or a whole lot of guidance around what we have to do when we have private education loans or what are called preferred lender agreements, which is a little bit tighter relationship with someone offering private education loans. And it's time, in light of these recent rulings, to dust off those regulations. I had to go back through and read all of them and see what they require and importantly, see what they might cover. So here's our first poll question of the day so you can get your continuing legal education credit. Does your institution offer or promote private education loans? Yes, no, or I'm not sure. And because we've seen so little guidance from the department recently, I think if you have any sort of creative or alternative funding mechanism for your students, the answer might be, I'm not sure, because now we need to go back and look at things that might be like ISAs and see whether they qualify as private education loans. So let's break down private education loans a little bit. They are loans provided by private educational lenders, which might include the institutions themselves, that are not Title IV loans, so these aren't direct loans, they're not PLUS loans. They're issued expressly for post-secondary education expenses, tuition, fees, living expenses while you're in school, to a borrower, which would be a student, regardless of whether they come through the education institution or directly from a private lender. This definition clearly covers more than income share agreements. It covers traditional private bank loans that you may need to get, that I had to get way back in the day when I was in law school to get through law school. They're loans made by your institution directly to students. And now that the department has said that ISAs are private student loans, consider whether there are similar products that Ed might classify or treat or require you to comply with the compliance arrangements around private education loans. So think about, situations where an employer might pay tuition in exchange for a commitment to work. Is that a private education loan, which would trigger the private education loan compliance requirements for your school? They fall in a really nuanced space in higher education law between Title IV requirements and state and federal lending and consumer credit regulations, and how they're treated depends on a number of factors, including the structure provided for repayment and whether you charge interest and things like that. There are penalties for violating those requirements. They can be really high, such as in the case where a private education loan is covered by the Truth in Lending Act, and you might have statutory damages for any violations. And especially in light of this new guidance around ISAs, we recommend using care to make sure that your financial aid office has looked at whether you need to comply with those private education loan requirements. Those requirements are laid out. I think the easiest place to reference them are the Federal Student Aid Handbook or this new round of FSA assessments that the department has provided to schools. Those are checklists that you can use as an institution to make sure you're meeting various compliance requirements. The department just published a notice saying, hey, we have some updated checklists. They're great for private education loans as well as various other aspects of Title IV compliance. And the basic requirements for private education loans are that you make certain disclosures, that in some cases at least, you issue a Truth in Lending Act self-certification form. The regulation requires you to file an annual report to the department about your private lender arrangements, but I don't believe the department has ever implemented a system for filing that report. So consider whether compliance is necessary or even possible. This is a really murky area of regulation, so at least to the extent that it's looking at non-traditional funding products, this is a great time to go back and circle back to the disclosures that you're making to make sure that they're compliant and maybe get ahead of some potential program review or consumer finance findings that your institution might have around things like, most importantly, income share agreements, now that we have, thankfully, some clarity around what they are, but possibly other student funding products as well. So speaking of program reviews and department findings, I'm going to turn things over to Elizabeth, who is our non-discrimination guru, to talk about potentially discriminatory scholarships.
Thank you, Annie. So we're going to spend some time this afternoon talking about sex-restricted scholarships and recent OCR enforcement related to the same. But want to just talk first generally. Of course, whenever institutions are considering administering restricted scholarships on various bases, they need to be mindful of the legal considerations. And depending on the basis at issue, applying the framework provided by the Supreme Court in analyzing equal protection claims. So using strict scrutiny, intermediate scrutiny, and rational basis scrutiny. We know, of course, that in terms of student funding, scholarships are an important component to that in terms of offering your students access to an affordable education. So when it comes to scholarship restrictions based on race, color, and national origin, just to say a word about that, university admissions cases can be instructive, including the upcoming Harvard admissions case that will be heard by the Supreme Court. Since these types of scholarships are subject to Title VI and the more exacting scrutiny under the Equal Protection Clause, institutions should, of course, be aware of how scholarships with race, color, and national origin restrictions are being structured, and working internally with campus partners in advancement and scholarship provision and counsel in terms of those scholarships. So moving now to the specific issue of sex-specific scholarships. According to the Title IX regulations, institutions are generally prohibited from providing a different amount or a different type of financial assistance or limiting eligibility to financial assistance on the basis of sex. So single-sex scholarships or sex-restricted scholarships that require either limit eligibility or express a preference are generally prohibited with some exceptions if certain criteria are met. So first, a school can administer a scholarship, fellowship, or other financial assistance if established through a will, trust, or similar legal instrument that requires that the awards be made to members of a particular sex specified in the terms of that agreement, so long as the overall effect of the award does not discriminate on the basis of sex. And so if a school is relying on that exception, that is a donor agreement, there must be certain kind of procedures to comply with regulations. Some schools achieve this by what's come to be known as pool and match system, wherein generally there's a pool of funds, both restricted and unrestricted, and the institution can demonstrate that even though some restricted funds are going to individuals on a sex-restricted basis, others who are maybe disadvantaged perhaps by that restriction are still receiving the full amount of aid that they would be entitled to and on an equal basis. Another scenario under which sex-restricted scholarships may be permissible is when such scholarships are being administered and awarded to overcome the effects of historically limited participation, and we'll discuss that more in a moment. So OCR released guidance in January of 2021 detailing questions and answers regarding OCR's interpretation of Title IX and single-sex scholarships. They also included some guidance related to clubs and other programs, but we'll focus here today on scholarships. So they issued some guidance related to the title of scholarships and fellowships. They can have a title with a name of a person as long as both men and women are eligible to apply on equal terms. For example, the Jane Doe Scholarship would be permissible. They did caution against scholarships or programs that are titled in a way that raises an inference that the institution might be imposing a preference or a restriction when in fact they may or may not be. And so an example is an award for student mothers could be renamed as an award for student parents to address a potential inference of a sex restriction. So again, then considering that generally these types of scholarships that impose restrictions are prohibited, as I mentioned, in some cases, schools can offer these forms of financial assistance that have a preference if they are taking actions to overcome the effects of conditions that resulted in historically limited participation in their own education programs and activities. So OCR has acknowledged, for example, that schools might, under certain circumstances, be providing such scholarships, for example, to women in programs that were traditionally dominated by men to overcome the effects of these conditions. The important key here is that institutions can't rely on nationwide statistics, but have to be able to articulate, sort of data and participation rates at their own institutions. And then, OCR has explained that they'll evaluate the sex-based classification to determine whether it's supported by an exceedingly persuasive justification based on the relationship between the sex restriction and the interests at the institution. And then finally, one thing to note from the guidance is about scholarship promotion. So generally, institutions can't promote third-party scholarships to students if they impose a sex-based preference or restriction, if the institution is providing significant assistance to that third party. And that can be obviously kind of a fact-specific determination depending on how the institution is publicizing or administering that scholarship. So it's important to kind of take inventory of how those are being publicized and the level of connection between the institution and these third-party scholarships. So a poll question for your consideration here. Have you conducted an internal audit or evaluation of sex-restricted or sex-preference scholarships at your institution? Yes, no, I'm not sure. I'll give you just a minute to answer that. Okay, so looks like about half are saying no, around between 15 and 20% are saying yes, and then others are not sure. We just raised this because we've received or there's been more kind of enforcement actions and investigations on the part of OCR. One way that institutions can respond to that is by taking sort of a proactive look at these various scholarships. And when doing so, a good start is to sort of take inventory of the scholarships and determine in which category they may fall. So the first category here would be institutional sex-restricted scholarships. So not meeting the donor-restricted exception, but may, depending on the particular institutional or programmatic data, meet the allowance for restricted scholarships to overcome historic effects of limited participation. So in looking at sex-restricted institutional scholarships, considering whether the restriction will remain, and if so, making sure that there's a demonstrated remedial need that the institution can provide. And if it won't remain, sort of perhaps modifying that restriction and communicating through different language, who is eligible and how it might be awarded to various individuals. Then the next category, of course, is donor-restricted, donor sex-restricted scholarships, and again, those are ones that are administered according to legal instruments. And so institutions may be, consistent with the donor's intent, awarding those monies on a sex-restricted basis. And again, if doing so, need to evaluate those and consider if that will remain, whether there is some institutional kind of pull and match that's being provided, or perhaps making some other arguments related to those donor sex-restricted agreements. There are also, depending on the nature of your various offices and the relationships with donors, perhaps there's flexibility with respect to the donor agreement and reestablishing some of the parameters and criteria that will be applied, for how those monies are awarded. And then another category is others that may have, for example, a sex preference, not exactly being sex restricted, but somehow having a preference. And those require also consideration by institutions in terms of whether those preferences will remain, and if they will not, again, modifying language perhaps, modifying through training, how those scholarships are administered and considered by the committees that are, reviewing those applications from students.
And Elizabeth, I'll jump in. I see we had a question about whether an endowed scholarship fund agreement is a legal instrument or whether it truly has to be a will or trust. And you know more about these than I do, but as I recall, the regulatory language is a little bit vague in that it says a will, trust, or similar instrument, and we don't have a pat answer from the department about whether it interprets that regulation to mean that an endowed scholarship fund agreement, like a gift agreement with a donor, is a similar instrument to a will and trust.
I think that's right, Annie. And so on those, I would recommend that sort of, as we were discussing, kind of categorizing and evaluating the types of scholarships that are being, awarded on an institutional basis, that sort of institutions kind of, seek some guidance related to whether those, which category they might fall into. So in terms of, again, kind of enforcement actions, in the fall of 2019, an organization called Save Title IX began writing letters to institutions insisting that they respond to concerns specifically about female-specific scholarships. And they generally fell into two categories: those that Save suspected were administered by an institution, and also those that were administered by third parties but were listed for promotional purposes and informational purposes by institutions. And then in addition to sending letters directly to institutions, the organization also filed complaints with the Office for Civil Rights, which have resulted in scholarship complaint investigations. So the process that has played out, for institutions who have, received such complaint investigations is similar to that, with respect to other OCR enforcement investigations, where OCR evaluates the complaint for jurisdiction and then proceeds with typically a data and information request. And so in these cases, includes requests for description of the certain scholarships, including how they're advertised, information about funding for the scholarship, a description of the eligibility requirements and the selection process, of course, data about applicants and awardees, and then an explanation of whether the scholarship has a preference, a limitation, or a restriction based on sex. So, if you haven't, received a notice of such investigation, there are some things that, we would encourage you to consider. Again, kind of taking inventory of these scholarships and considering the institutional goals around these scholarships, looking at policies and procedures regarding methods for administering or listing scholarships on the websites, and then considering options, again, related to donor relations for how to offer these scholarships. So perhaps language that allows the institution discretion in administering them if the sex restriction is at some point deemed illegal, so that you as an institution have some flexibility in responding to that. Of course, we recognize that the donor relations and the ability to receive gifts and administer them consistent with donors' intent are significant to university relations, and so collaborating among the campus partners with your directors of scholarships and financial aid and advancement and plan giving can really be beneficial towards kind of addressing compliance in this area. So institutions have been considering or implementing policy and procedure revisions related to these donor agreements, and through that collaboration, considering additional vetting for scholarships with these types of restrictions, and some are moving towards processes and donor engagement that expands the number of eligible students by expanding the criteria to include other experiences and affinities. Okay, and now we'll spend a few minutes talking about an issue related to eligibility for Title IV program participation. So as background, I just want to begin with a brief explanation of the three main levels of eligibility schools must consider as to aid, and then we'll discuss another aspect related to eligibility, specifically location, in a bit more detail. Obviously, with all of these topics, we have to kind of hone in and talk about a few things in some detail, but each of these issues could be their own webinar in its own right, so we're doing our best to try to give you kind of a wide range of information on some of these key topics. So for those of you who may not be as experienced with respect to Title IV eligibility, there are three key components to Title IV program participation: institutional, program, and student eligibility. So in short, federal student aid may be offered to eligible students enrolled in eligible programs at eligible institutions. And so in order to receive authorization to participate in these Title IV programs, institutions have to demonstrate to the department that they're eligible and that they offer at least one eligible program. So first, with respect to institutional eligibility, an institution must be legally authorized by a state to provide a post-secondary education program in that state. And then this component, as applicable, includes accreditation by a nationally recognized accrediting agency or alternative requirements. Next, with respect to program eligibility, this includes whether the program is of a type that can receive aid. In most cases, does it lead to a degree or gainful employment, and sort of looks at whether it provides an associate degree or higher, or training to students for employment in a recognized occupation, and is a certain number of hours and length. And then finally, student eligibility, including compliance related to credentials of admitted students, and then student eligibility related to U.S. citizenship or a small group of others who can be eligible. So then finally, though discussed less often, there are eligibility requirements related to educational location, and so just want to spend a few minutes talking about that today. So if a school is offering programs at a new location, eligibility requirements may be triggered. So new locations require, of course, state authorization and possibly accreditor approval, depending on what the program that's being offered. In addition, depending on how much of the program is being offered at a location, schools will need to go through a recertification process with the department. So institutions initially complete, the electronic application for approval to participate in federal financial aid programs, and then this application is also used to apply for recertification when various triggering events occur. So changes in eligibility, including the addition of new locations. And this will result in some modifications to, the institution's e-card, which provides the summary of schools' participation, programs, and locations, including these additional locations. So if a school is offering 50% or more of an educational program at a new location, then the school must receive state or government approval and accrediting approval, and then also report that new location to the department. A key sort of compliance point here is that sometimes an institution can miss achieving the 50% mark. So as programs are growing, which is of course a wonderful thing for your institutions, you need to make sure that institutions, those at your institution with such responsibility are tracking how much of the program is being offered where. So it's important to carefully track the growth of these programs at new locations to sort of be monitoring that 50% mark. So, if an institution doesn't plan to offer at least 50% of a program at a new location, it will not be required to report it to the department and to get department approval. But at times, in our experience, Ed can apply different interpretation of programs and have a different interpretation of whether that 50% mark has been met. So it is an important, again, kind of aspect to track that growth and when an institution might be getting close to that mark for a new location. So an additional location, by definition, is, of course, geographically apart from the main campus, and then again, at which an institution offers at least 50% of a program. And then in most cases, once an institution has reported the additional location and obtained the appropriate licensure, the institution may begin offering FSA to students enrolled in that location. There are some particular issues depending on the new location that may arise, and one area that we've seen is when an institution has acquired an additional location from a closed school that might have outstanding FSA liabilities. So Annie, can you give us some just high-level recommendations related to that when institutions are in that situation with respect to a new location?
Of course. So, Elizabeth, you mentioned there are times when a school can just report and go. So they can tell the department, we've got this new location, we're going to start offering Title IV, and the school can go ahead and do that. And there are other times when the school has to get department approval before it offers Title IV and before the location could be considered eligible. One of those times is, for example, if you're on provisional certification. You need to get approval. But then also, we've seen a lot of mergers and acquisitions in the higher ed world recently, and just like that circumstance you were talking about where academics may not be talking to the Title IV office and saying, hey, we're starting to offer more and more courses, so we're crossing the 50% mark. Sometimes the business people at an institution aren't talking to the Title IV office, and they will go ahead and say, purchase a closed school or purchase a school that's in teach-out. And in cases like that, depending on the circumstances, the department may take the position that either you can't offer Title IV programs at the new location for a couple of years, or you have to assume certain Title IV liabilities from the school that you're acquiring. We certainly see this regulation as applying to situations where you're acquiring the institution as opposed to just its property. But if your business people are considering that sort of merger acquisition situation, consider carefully how we're going to implement a new location on that site and what your timeline is, so that you can make sure your plans are lining up with department requirements, and to the extent you need to, that you're talking to the department ahead of time to make sure we get a full picture on what it is they expect.
Yes. Thank you, Annie. Yes, so as Annie mentioned, in that particular situation, it is really advisable to maybe consult with the school participation division or with council as you're thinking about transitioning to offering these programs in new locations. And now I'm going to turn it back over to Annie to discuss cybersecurity.
Thank you. And I'm going to do this quickly because we have not heard a peep from Julie Maselli yet, and I know she's excited to tell us about policy developments in higher ed, and in part because I wish that I had answers for you around what it is the department specifically is expecting with respect to cybersecurity, particularly the FTC's newish safeguards rule, but we don't have firm answers yet. In terms of higher ed and cybersecurity, I think you all know that you have a breadth of operations and that your primary mission is not super sophisticated business operations. You have a lot of people with access to information who are focused on providing quality education to students and getting student support, and not necessarily honed in on things like the Graham-Leach-Bliley Act or the Financial Services Act, which through your Title IV program participation agreements and through Department of Education guidance, your institutions are, at least arguably, certainly in the case of Graham Leach Bliley, you're obligated to comply with those. In terms of cybersecurity broadly, I will not claim to be your guru, but I will offer some understanding of what it is the department expects when it comes to your federal student aid programs and cybersecurity. Sean Tassi is probably the most knowledgeable in our group around cybersecurity more broadly outside of the student funding context. So you have the Graham Leach Bliley Act and you have the Financial Services Act. What does the Department of Education require you to do in terms of cybersecurity, particularly as a Title IV participant? With respect to Graham Leach Bliley, it's a framework for regulating data privacy and data security. It's aimed at financial institutions, but again, you signed your program participation agreement, which is a contract you have with the department allowing you to participate in Title IV programs, and that says that you will comply with Graham Leach Bliley. And that means you need to have an information security program contact, commonly called a CISO, C-I-S-O. You need to do periodic information security risk assessments. You need to have safeguards against risk of breach. You need to oversee any third parties that are providing services to your institution. And you need to periodically evaluate and adjust your income security program over time. We see program review findings from the U.S. Department of Education when it comes in to do Title IV program reviews around GLBA noncompliance, mainly because you are not performing risk assessments. Sometimes it's because you haven't met some of these other elements, but that's really that risk assessment and improvement is the most common program review finding in this area, or audit finding. You also have SAIG agreements. Don't ask me to tell you what SAIG stands for off the top of my head, but it's the agreement you have with the Department of Education that allows you to access things like the G5 system, which is a system that your institution uses for drawing down Title IV funds. Also things like iPads or other government systems can be linked to your SAIG agreements, and those include a provision that expressly calls for you to report certain security breaches to the department. And those are breaches of what we would call financial aid student data. So it's not every single breach that you ever have, but this is what your SAIG agreement calls for. Sean, I know, commonly works with schools around, thank you to the person who just told me that SAIG stands for Student Aid Internet Gateway. Sean commonly works with schools around issues of data breach in this area. They can be very nuanced, and it's important to use care and consider all factors that might come into play around this. Interestingly, the department has promised us that further guidance is forthcoming in 2021 around how we should be implementing the safeguard rules at colleges and universities. For a while, the department a few years ago was really gung-ho, insisting that institutions come into compliance quickly, including compliance with the rather complex NIST 800-171 version 2 requirements, but in recent statements, the department has suggested, without expressly stating, that it realizes these are extremely sophisticated and complex requirements, and that implementing them across the breadth of your operations can be difficult and can be extremely resource intensive. And I truly appreciate that the department seems to be taking a nuanced approach before issuing guidance around what schools need to be doing. We didn't see guidance around this in the newly released set of Title IV FSA assessments that I mentioned earlier. We have seen the department, when we call with specific questions, be as responsive as I think it can be around specific questions about what systems schools need to be considering and applying these standards to. What can you do in the meantime? You can certainly comply with your GLBA requirements. It's clear that you need to do that, those 5 factors listed above, and you can assess what systems you have now and what types of information they're holding, so that when we do finally get guidance from the department, you will have a faster path to prioritizing where you need to implement these new requirements. So speaking of pending guidance, I'm going to hand the mic over to Julie, who I will venture to say has the most, or at least one of the most informed crystal balls in our group around predicting what the department's next steps are going to be around various policy initiatives. Julie?
Thanks, Annie, and thanks, Elizabeth. I've been enjoying listening to the both of you on all of these topics, and I kind of got a chuckle when I heard Elizabeth say each one of these could be a webinar in its own right. And I agree entirely with that. I also feel that all of the topics I'm about to cover could be their own webinar. So we're going to try to cover these at a 30,000-foot level, and of course we're here for questions. We'll try to play follow-up, and feel free to reach out to any of your HB team members if anything we've said today has raised any questions for you. So I'm going to start with a poll question. Is it pushed?
It's pushed.
Yeah. There we go. Which Title IV compliance area do you feel least confident about? The one that you would like some extra attention and care on? We've got financial health, borrower defense, gainful recertification, R2T4, your team administering and packaging aid, or all of them. So let's see what the results say. Oh, most of you are saying all of them. I've got a number of you with gainful employment. I think it's fair to say, especially in this environment with the Biden administration at the helm, there is going to be a lot of regulation and changes with all of these policy and regulatory areas, and we probably need to be paying attention to all of them. So I appreciate those of you who selected item G. So let's get into some, I wanted to start with some good news. So the first policy development I wanted to cover is on loans and Pell. Just to start with a little positive news before we get into things that are a little bit more complex and mind-numbing. So first of all, we know loan repayments were paused due to COVID, due to the pandemic, and that started very soon after the pandemic began in March of 2020. Right now, that loan repayment expectation is still paused until August 31st of 2022. So this year, this summer, in theory, that pause is going to be relifted so that we will start to see students and borrowers having to start repaying their loans unless that is extended further. And hopefully there will not be another uptick in COVID and we're on the downswing of this whole pandemic so we can get back to normal, whatever that looks like. I wanted to note that in Biden's budget proposal, he actually called for doubling the maximum Pell Grant by 2029. I don't know that the doubling of Pell is going to pass, but we are seeing some significant and bipartisan advances for increasing the maximum Pell award. And hopefully through that budget proposal, at least something as far as an increase in Pell grants will continue to increase. Right now, the Biden administration went out with a little factoid that in 2020 they feel that the maximum Pell is only covering less than 30% of tuition fees, room and board, so all costs of attendance at any four-year public university. Certainly, for any of you who may have been in college in the 70s and early 80s, that was a very different number. The states were investing and federal government was investing in college and higher ed in a very different way than we are seeing now. And so the scrutiny on Pell has been that it's not keeping up with even the cost of inflation, let alone rapidly increasing cost of attendance. And so we are optimistic that institutions, that higher ed as a sector is going to see some Pell Grant improvements over the next several years, potentially doubling by 2029. The department is also working on new loan forgiveness programs. There were a number of programs that the Obama administration was working on that were income-based repayments, some programs for forgiveness on specific types of professional areas like teachers. The new one that they're focused on is pay-as-you-earn. It's sort of a reboot of these income-based repayment plans that the department was working on about a decade ago. And we anticipate that through the negotiated rulemaking and now regulatory process, we're going to see some improvements on forgiveness programs. All of that I see as good news for the sector because higher ed's Title IV Act, the Higher Education Act, Title IV, really is the lifeblood for all of what we do. And so the more dollars that are getting pumped in to support students attending college and higher education, the better. So we wanted to start with some good news, but I'm going to get into some tougher policy developments that we need to be paying attention to. The first one is borrower defense, and a number of these are going to come directly from the negotiated rulemaking that just wrapped up in March and is now moving into its next phase, where we anticipate proposed rules on a number of key policy areas. One of these is borrower defense, and as a reminder, even though there has been quite the sordid history with the borrower defense rules from its inception, there are still borrower defense regulations in play and on the books. So we have this administration who is actively looking and reviewing discharge applications from students, so borrower defense to repayment applications, and right now the department has discharged over 100,000 student loans, totaling over $2 billion just since this administration has been in office early in 2021. These recent discharges have occurred primarily from borrowers within the for-profit sector, but we are seeing a bit of a transition of the department moving on from discharges for borrowers who are attending now closed schools to looking at and actually discharging loans for borrowers who are in attendance at schools that are actually in operation now. So for those institutions facing those borrower defense claims, it is very possible that after the department has decided to discharge those loans, that they are then going to look to recoup those funds on behalf of the taxpayer from the institution. As a reminder, borrower defense reporting is still in effect as modified, not as originally put in place by the Obama administration, but there are still requirements for reporting liability from settlements, final judgments, and determinations when those settlements, final judgments, and determinations are arising from an administrative or judicial action that was initiated by a state or federal agency. So as a reminder for those of you in the counsel's office or HR, when you are working on settlements that might be coming from a state or federal proceeding, there is still a reporting requirement for those. A lot of the other reporting requirements that we may have worked through a couple years ago on borrower defense have been put as discretionary requirements now, but please don't forget about the mandatory one that's still on the books. So the department is pursuing new regulations on borrower defense, even though it has existing rules currently. The goal of those new regulations would be to improve the ease of application for borrowers and also the administration. And this matters because, as I said earlier, once a loan is discharged by the department has the ability to recoup on behalf of the taxpayers those dollars from the institutions directly. And this seems to be a very hot time for borrower defense claims coming into the department. We are seeing attorneys general across the country, members of Congress, and even some professional industries that are recommending to borrowers that they consider applying for loan discharges now. So this is a very hot time, and we anticipate seeing continued spikes in discharges for borrowers out there. I was just looking, I think, on Above the Law, which had an article for borrowers who have loans from law school to consider whether or not that's something they want to pursue. There's another policy development area to cover is the 90-10 rule. I'm going to go through this quickly because it applies to proprietary schools. I know there's a number of you on the line, but this is a requirement only specific to that subsector. The 90-10 rule originally set a 90% limit on proprietary schools' revenue coming directly from Title IV. And then we saw in 2021, the American Recovery Act actually addressed the 90-10 rule and sort of set the stage for some new interpretation by the department by reciting that that 10% of revenues for for-profit schools needs to come from other funds aside from federal education assistance funds. And then ask the department to go and interpret that. And as a result, through negotiated rulemaking, we have what we believe is going to be a draft rule. We have a draft rule we'll see likely in proposed form soon that interprets federal educational assistance to include other federal sources like GI benefits, military tuition assistance, and then federal grants and programs that support tuition fees and charges. Essentially what this is doing is it's narrowing the ability of for-profit schools to comply with the 90-10 rule by making it such that the 10% can't include those veterans benefits and GI benefits, but rather that gets factored into the 90% rate, part of the ratio instead of the 10. There's also some other limits on how institutions can support demonstrating the other 10% of aid is coming from other sources through things that they may do, like income sharing agreements and plans that Annie covered earlier, and also institutional loans. Just as a reminder, while we do have a consensus from the Negotiated Rulemaking Committee on this new draft proposed rule, there is some regulatory process yet to go underway. We're going to see a proposed rule, and we think that will likely go into effect by about July 1, 2023 after it's finalized. So it matters because it is a very significant change to the 90-10 rule, which has been in place for some time. It also matters that it shows that the Negotiated Rulemaking Committee was willing to make consensus on this, so sector representatives, the Department of Education, and other negotiators felt that this was the right way to go. And as a reminder for the proprietary institutions on the line, failure to comply with 90-10 is a Title IV eligibility requirement. So there's going to be some time to think this through and make sure you're ready for compliance under this new way to calculate 90-10. But it certainly is an important issue for that part of the sector. There's more. I couldn't keep going with I had to put all of these on one slide so we would have some time, but I just couldn't let myself not share some information about these other key topics, so we're just going to try to cover them quickly. A number of these are coming from the Negotiated Rulemaking Committee, again, that was meeting from October of last year through March of this year, and working towards new regulations in the Title IV space that we are expecting to see in proposed form sometime. I would anticipate this spring or summer, perhaps as soon as tomorrow, though. The first one is gainful employment. There was no consensus reached on any proposed gainful employment regulations. And that was to be expected. As a reminder, the gainful employment rules try to set a bar to establish a debt-to-income ratio for completers of applicable programs. Those are often the programs offered by for-profit schools, but also certificate programs that are offered by nonprofit, private, and public institutions. We anticipate that the department will release a high bar in its proposed rule. So when we see it, the first thing I would suggest that all institutions do with gainful employment programs is take a look and see if they feel that, through some estimation, whether or not the debt-to-income ratio for those programs is going to be able to meet that bar. And certainly we expect some controversy around this rule, and perhaps even some deal making, perhaps in what we see from proposed to final. So we'll have to see where the department ends up. It is a very critical and complex compliance requirement, so it does matter to any school that has a gainful employment type of program. Another important one is administrative capability. This was an issue that was covered by the Negotiated Rulemaking Committee. It's essentially where the department is looking to define what it means for an institution to be able to adequately administer Title IV, which is a bar. It's supposed to be a low bar to ensure that schools are able to participate in the Title IV program, but with all of the complexities and requirements around Title IV compliance, we as practitioners all know that this is actually a very high bar. It matters because the department has played with administrative capability findings, concerns about whether an institution may have administrative capability in its program reviews, and failure to do this really would serve as an eligibility requirement. It's a compliance issue, but if an institution can't demonstrate that as a whole, within the financial aid office, but then at the institutional leadership level as well, that it can't administer the Title IV programs in compliance, then the institution's participation is on the line. So again, there was no consensus on this. We're expecting to see a proposed definition of this through proposed rules again this spring or summer. Another one is incentive compensation. Here we got some we anticipate seeing some renewed guidance from the 2011 guidance, which was the last time we received something formal from the department on this issue. There was a report that from some insiders that the department is considering revising its 2011 guidance on how bundled services, or OPMs, online program managers, and their services are considered under the incentive compensation rules. The goal, and I always think the goal and the underlying policy purpose is a really interesting thing to explore with all of these compliance requirements. And here, the department's goal is to avoid predatory practices in recruitment that may be occurring because there's an incentive on those OPMs to try to recruit at higher numbers, as opposed to finding students who really can benefit from the programming. There's a balance, though. OPMs serve a purpose in allowing institutions of higher education to get online, and a lot of schools did not have that capacity in-house and relied on OPMs. So there is this sort of conflicting interest that the department's trying to manage. What we're saying is right now it's a very good time for institutions to start looking at your OPM contracts and be ready for potential revisions based on what these potential guidance that may be coming. And be ready to negotiate, because I promise you those private contractors out there with very large contracts, they're going to be ready. So you as an institution need to be ready to make sure that you are arriving at a solution with your OPM provider that is cost efficient for you all. Another one is there was PPA guidance, or program participation agreement guidance, that was just issued in March. Essentially the department, again, the underlying policy goal here is the department is looking to require more skin in the game from the owners, the members, and investors of schools. Typically, the school signs its own program participation agreement, and it is the one that is on the hook for Title IV aid should something like a significant number of borrower defense claims face it in the future. Now, for those of you with parent institutions or parent parties that sort of go up the chain on your ownership, this is something that they need to be paying attention to, because through recertification or changes of control, the department's going to be looking to immediately require that those parents, depending if they meet certain requirements, be signing those PPAs, saying, hey, we're here to financially back and support the school, and we are on the hook too. This is a very significant change in guidance. I know some in the sector have been questioning whether or not there may or may not have been authority to do something like this without going through the regulatory process. We'll have to wait and see if there's any lawsuits that might look to challenge this in the future. But right now, we just are living with the guidance. So the last one I'm going to just summarize is that as a team, we are seeing a lot of activity in Title IV program reviews. We are seeing continued activity in the Clery compliance review side of things. And then again, through negotiated rulemaking, where there were two committees, one subcommittee, all of which were meeting between October and March of this past year. We are expecting a mother load, I think is the right way to say it, a mother load of proposed regulations sometime this spring and summer, and probably into the next year. The one thing that the Department of Education has to contend with is its master calendar requirement. So this calendar requirement is in the HEA that requires, for most Title IV regulations, the department has to publish final rules before November 1 in order to be effective the following July. And that lag in the effective date of most regulations in this space is to allow institutions to come into compliance. If they miss that November 1 deadline, they're essentially pushing out their final rules another year before they can be effective. It all matters because we are going to be seeing proposed policies and also new policies coming through all of these mechanisms over the next 2 years. And I think for those of us in the Title IV compliance area, we're going to be extremely busy. So we covered a lot here. I'm going to turn it back to our moderator to wrap us up, and we will contact you for responses to questions in the coming weeks.
Thanks so much, Julie, and thanks to all of you for joining us today. We hope the information was helpful to you and to your school or organization. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And be sure to complete our short survey. We really do use your feedback to design programs that may be helpful and address your interests in the higher education space. This concludes our webinar. Thank you.